Earlier this year, a DC appellate court let the Trump administration off the hook for their alleged defiance of a court order to turn around airplanes filled with hundreds of immigrants bound to El Salvador. While they may not be out of the woods yet, there's an appeal that's recently lodged. Here to discuss various different elements of that litigation is Lee Gelernt, the Deputy Director of the ACLU's Immigrant Rights Office. Thank you, Lee Gelernt, for joining us.
Thanks for having me.
So tell me, what is the status of the case right now when you filed JGG versus Trump? It's gone through a number of permutations, went up to the Supreme Court and back. What's going on in that case?
Yeah, so I don't want to make your audience's eyes glaze over, but there are sort of three parts to it, and I'll just set them all out. One part is whether the Alien Enemies Act can be used going forward. And what the Supreme Court said is that we need to file cases where individuals are being detained. So that meant filing multiple cases all around the country because the government was detaining people all over the country for removal under the Alien Enemies Act. And we had to file what were called habeas corpus class actions. So we had multiple of those cases all over the country. Overwhelmingly, the court said that the president's use of the Alien Enemies Act was not proper because we weren't at war with a foreign government. Those cases have now gone to the courts of appeals, and there's one test case, and that's out of the Fifth Circuit Court of Appeals. We had oral argument on June 30th down in New Orleans. In that case, we're waiting for a decision. It's likely that case will then go back to the Supreme Court this fall, and that will decide whether the Alien Enemies Act can be used going forward.
And to give a little bit of background on the Alien Enemies Act, it's this wartime statute that had been used 3 times in U.S. history. And when Trump tried to justify it on the grounds of an invasion, and most judges have been very skeptical of that proposition, rejecting it outright. Do I have that correct?
That's exactly right. So the law was passed in 1798 when the country was just starting out to give us the same authority that other countries had under the laws of war, which meant if we go to war with another country, we have the right to then name everyone from that country an enemy alien who's within our borders and remove them if we wanted. But it was supposed to be a very, very narrowly tailored law, only used during wartime. And as you said, it's therefore only been used 3 times in our country's history: the War of 1812, World War I, and World War II, all during major declared wars where we treated people from those countries who we're at war with as enemy aliens. The Trump administration has now said, well, we're going to use it against a criminal gang, even though we're not at war with Venezuela. And so it's a dramatic expansion, unprecedented expansion of the use of a military authority. And on top of that, I think what sometimes people miss is, well, they say, well, don't we have to remove people if they're actually very dangerous? Well, there are plenty of laws that allow the removal of these alleged gang members if they turn out to actually be dangerous gang members or have committed crimes. And so that option was always available to the Trump administration, but they wanted to do this dramatic theatrical thing of invoking a wartime authority. And that's what courts have pushed back on. The other part of that stems as well from that night on March 15th when the government sent these men to the Salvadoran prison, which is that Chief Judge Boasberg has issued a finding, a possible probable cause finding of criminal contempt, saying that the government may have willfully violated his order not to send the men to El Salvador. And so that is going forward. It went to the Court of Appeals. The Court of Appeals, after 4 months, issued a 2-1 decision that he should not actually look at the executive branch whether the executive branch willfully disobeyed his order. And so we are now about to file a petition for rehearing at some point, and that will then put the case back potentially before the full Court of Appeals, and that'll be whether the government violated his order. So there's two parts to that original case. One is still trying to get the men back who are now in Venezuela, and largely men. And the other part is whether the government will be held in criminal contempt for potentially violating, willfully violating his order. And since he issued that order, a lot of whistleblower evidence has come out saying that the Department of Justice, the lawyers involved in the case, actually understood that they weren't supposed to turn people over to El Salvador, yet the administration did it anyway. So I think that's potentially going to be very explosive.
And that's the whistleblowers who stepped forward against now federal appellate court judge Emil Bovey, who was then a senior DOJ official. Is that correct?
That's exactly right. That's Erez Ravani's whistleblower complaint. I think there may be other whistleblower complaints out there that we don't know that much about, but he's the one who came forward and talked about that meeting in advance, that they may not adhere to a court order if one comes, but also talking about the fact that he informed the administration over and over that night that they could not take people off the planes in El Salvador and hand them over to El Salvador, and they did it anyway. So, the stakes for these men and use of the Alien Enemies Act is enormous, but I think equally as important is going to be whether the executive branch feels like they can willfully disobey orders of the court. If that happens and the judiciary doesn't put its foot down, I think that changes the dynamic between the branches and really puts us on dangerous ground.
Right. So if you lose your appeal and you're taking this to the full DC Circuit bench, what would that mean in terms of accountability here? Because what teeth can a federal judge's order have if they can't enforce it through all means, including criminal contempt?
Yeah, so that's a very good question. I think if we don't prevail, we'll have to see what grounds we didn't prevail on. But, broadly speaking, if the administration is going to violate orders and the judiciary is not going to stand up to that, it's hard to sort of see where things go from there. But as I said, I think we're in a very dangerous territory because ultimately the system depends on both branches complying with court orders. The sort of standard line is the courts don't have their own army to enforce their orders. And so at the end of the day, we need the administration to comply with orders. And right now, they don't say outright they will not comply with orders. They're constantly finding ways to claim that they adhere to an order. We don't think those claims are plausible, and certainly not in this case, but we'll have to see what the judiciary does. So the third part of it also stems from that night on March 15th. What happened was that although the judge issued his order saying the men were not to be turned over and were not to be removed to El Salvador, but brought back to the United States, the government did so anyway. The government handed the people over to El Salvador. The judge understandably was very concerned and has spent months trying to understand what the government was thinking about why they handed over the people to El Salvador, notwithstanding his order that shouldn't happen in that emergency hearing that Saturday night in March 15th. Ultimately, he was not able to get information from the government. And this is Chief Judge Boasberg issued what's called a finding of probable cause for criminal contempt. And what he said to the government is, look, you can bring the men back and purge the contempt, or you can give me the names of the individuals in the administration who were involved in the decision to turn over the men to El Salvador, notwithstanding my order. The government did neither and went immediately to the Court of Appeals for the DC Circuit. The DC Circuit issued what's called an administrative stay, a temporary stay of Judge Boasberg's ruling, held it for 4 months, and then ultimately issued an opinion on August 8th. And it was a splintered opinion, a 2-to-1 opinion. One judge dissented and said what Judge Boasberg had done was absolutely fine. One judge said his order wasn't clear And therefore, the government didn't commit any contempt because they didn't understand. Couldn't turn the men over to El Salvador. Now, we obviously strongly disagree with that. The ruling was crystal clear by the judge. The other judge took a different tact and said, well, what I think is wrong is that he offered this purge. You can't offer a purge aspect, meaning you can't try to force the government into bringing the men back. And that gets very weedy and complicated, but that was Judge Rao's rationale. So ultimately it was 2-1 to allow Judge Boasberg to continue, but basically on such a short leash that it would effectively end any inquiry into the criminal contempt.
And as, oh, sorry, I didn't mean to interrupt. I was just about to say, as a little bit of background for viewers, the two judges who ruled against Boasberg and overturning the probable cause finding of criminal contempt were appointed by Donald Trump. And the dissent had mentioned, Lee, that her colleagues had performed, in her words, a grave disservice toward Boasberg, who had very carefully set up a ruling that would get at who allegedly defied his orders. It wasn't a finding of contempt. It was a path for finding contempt.
Well, exactly. And the government said, well, look, you can't refer us to a prosecutor. You can't do all these things. And what Judge Pillard in dissent pointed out rightly was that Judge Boasberg had proceeded very carefully and very methodically. He had tried to get information from the government. They had stonewalled him at every turn. He didn't just jump to referring them to a special prosecutor or make a finding of contempt. He simply said, look, you can bring the men back and potentially purge a possible contempt finding, or you can just start simply by giving me the names of the individuals involved in the decision, and we'll go from there. But the government wouldn't even do that. And so what Judge Pillard is pointing out is that Judge Boasberg really, really was careful and was made himself available on that Saturday night. If the government thought there was any confusion about what he wanted, they could have gone back to him in a second, but they didn't do that. They just sent the men to El Salvador and then retroactively created all these excuses. And so I think the importance of then the Court of Appeals saying, in the 2-1 ruling, overturning what Judge Boasberg did, the implications are enormous, because if the executive branch can resist orders or defy orders, and then the judiciary can't issue a contempt order, can't even look into it, we're on very dangerous ground. I think ultimately that is where the country really moves in a different direction. If we cannot count on the executive branch complying with court orders, that's a whole other world. And right now, the administration hasn't said directly, we will not comply with orders, but it is doing everything it can to circumvent the orders and then making up excuses. So we're getting very close. So a lot is going to now turn on how this case plays out. And I think what we are going to do is challenge the Court of Appeals ruling. And one option that I think we will take is to go to the full Court of Appeals, what's called an en banc, and ask that full Court of Appeals to overturn what the 3-judge panel did in that 2-1 splintered decision. And so we're hoping the full court takes action. If they don't, we'll have to consider what to do from there. But as important as the cases are about the Alien Enemies Act, and they are really important because we're talking about using a military wartime authority during peacetime, the question of whether the executive branch willfully disobeyed a federal judge's order has enormous ramifications by itself, regardless of the underlying dispute about the Alien Enemies Act. And so,
to put a fine point on what you're saying here, the stakes of this brand new en banc appeal are whether a federal judge can even inquire as to whether the government is defying and flouting an order.
That's exactly right. You put it exactly right. That's the specific question, because the government wants to jump to, well, can they be prosecuted? That question is off in the future, because we don't even know whether Chief Judge Boasberg will find contempt, much less prosecute. There's other remedies he could take. He could refer lawyers for disciplinary proceedings. He could just announce there's contempt, but not have a practical remedy. There's all sorts of things he can do. But right now, as you said, the question is simply, can he inquire into whether there was willful disobedience of a federal court order? If a federal judge can't even inquire into whether the executive branch deliberately disobeyed a court order, we're in real trouble. And so we hope that the en banc court will make absolutely clear that at this point, Chief Judge Boasberg should go ahead and methodically find the facts. If the government feels at the end of the process that something was wrong, they can always appeal then. But to cut it off now, that's very dangerous.
And to cast this into very sharp relief, the government, the Trump DOJ, has gone to war, it seems, with Chief Judge Boasberg. They have, in addition to the alleged contempt that is pending now, they filed an ethics complaint against him over something that he said in a private meeting. What can you comment on the government's conduct in trying to go in the court of public opinion, attacking him, trying to refer an ethics complaint, and being, it seems, protected from Trump appointees in the D.C. Circuit when Judge Boasberg tries to hold them to account for flouting an order?
Yeah, you're absolutely right. I mean, I've been practicing doing this civil rights work for more than 3 decades now. I don't think I've ever seen anything like what's going on in this case with Chief Judge Boasberg. I think in court and in their filings, sort of real disrespect for him and the judiciary, like nothing I've ever seen before. But then also every time he ruled in the beginning of the case, immediately going to the Court of Appeals, talking about having him thrown off the case, having the administration, the president talking about impeachment, to the point where Chief Justice Roberts had to come out and say, every time you disagree with a decision, you don't call for the impeachment of a judge, with them filing an ethics complaint, one after another. And you've seen now other judges come out and say, look, you may disagree with opinions, but this is not proper to single out the individual judges or the judiciary for this kind of attack, that this is a dangerous thing for our country. And, you can appeal cases, you can disagree with them, but for going after a judge individually is something that I have never seen. And I think Chief Judge Boasberg has been extremely patient with the government, but ultimately was getting nowhere, and finally said, I have to issue this order, this probable cause order, because you won't even give me the names to let me look into this.
And it sounds like, from what you're saying, from your pending appeal en banc to the DC Circuit, that the government isn't out of the woods yet for allegedly flouting the court order from Judge Boasberg back on March 15th. Is that right?
We hope not. I mean, we hope that the full Court of Appeals will overturn the 2-1 panel decision, but we'll have to see how it plays out, But I think we felt like we had no choice but to appeal that decision, to defend Chief Justice Boasberg. And, obviously, because it was our clients who ended up in that notorious prison because the government defied the order.
And just one more question, if I can, before you go. You mentioned the 4-month period of delay between the the Trump administration's appeal of the probable cause order on contempt, and a ruling from the DC Circuit. One of the things that happened during that period was Emil Bovee, a senior Trump DOJ official, is elevated and confirmed to the Third Circuit. By delaying for so long, did the DC Circuit avoid real accountability that was happening in the whistleblower report, that a fact-finding mission that could have uncovered and corroborated just what the whistleblower was saying?
Yeah, so I am not going to comment on what was going through the panel's mind. I don't know. Obviously, that was a long time to have an administrative stay in place, 4 months. Those are supposed to be for a few days, a week or so, a couple of weeks. And as you said, a lot has changed, including the fact that the whistleblower information came out. The whistleblower information, among other things, said that he had a meeting in advance that maybe where he said we potentially may have to violate a court order. But I mean, as importantly, the Justice Department lawyers who were on the case and were listening to the hearing understood precisely what Chief Judge Boasberg wanted, communicated that. What we are going to tell the Court of Appeals is, look, the order was crystal clear, but now there's evidence that even the Justice Department lawyers understood it, and the administration simply said, we're going to hand these men over because that's what we always intended to do, notwithstanding a court order. So we'll see how all that plays out. But there's a lot at stake here.
Mm. And for folks who may have remembered that whistleblower report, that was the same whistleblower report where Erez Ruveni had said that in a private meeting with prosecutors, Emil Bovee instructed prosecutors they might have to say F you to the courts. And whether they can say F you to the courts may be at stake in this pending appeal. So lucky that you're here to speak with us, Lee Gelernt. Thank you for your time and for helping us break it down.
Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.